Good evening, everyone, and we'll call to order the Tuesday, December 18th, 2018 meeting of the Everett Planning Commission, beginning with the roll call, please.
Chair Holland,
Here.
Commissioner Tisdall,
Here.
Commissioner Zielinski,
Here.
Commissioner Yanasak,
Here.
Commissioner McGinn,
Here.
Commissioner Lark,
Here.
Commissioner Dunn.
Here.
Well, we have first item on the agenda this evening is the approval of the December 4th, 2018 minutes. Is there any comments or corrections or motions on the minutes as presented?
I move to approve.
Second that. Any discussion? Okay, we'll call for the vote.
Commissioner Dunn,
Yes.
Commissioner Lark,
Yes.
Commissioner McGinn,
Yes.
Commissioner Yanasak,
Yes.
Commissioner Zielinski,
Yes.
Commissioner Tisdall,
Yes.
Chair Holland.
Yes. Any reports from the commissioners? Committee reports? Seeing none. Anything from staff this evening?
Just one thing, and that is that 3 of our commissioners' terms run out at the end of the year here. And while I know that 2 of them have applied to be reappointed, we won't know until maybe after the first of the year who the mayor appoints to fill those vacant spots. We had a nice round of applicants that have submitted their names for consideration, but Commissioner Dunn is not going to be on the commission next year, so I want to thank all of you for just your service and dedication as commissioners. We really appreciate you volunteering to come out on these winter nights, and we gave you most of the summer off this last year, but that I guess it was all of the summer. But want to thank you for your efforts and all that you contributed, and well, we'll see if our other 2 commissioners are reappointed or not, but we won't know that until after the first of the year. But as soon as I know, I'll let all the candidates who've submitted applications to be on the Planning Commission. We did have a nice field of very qualified individuals, so I appreciate those who aren't here but did apply as well, because they were very interested and some interesting candidates. That's all.
Great, thank you. Well, this is an opportunity from anyone in the audience that wants to address the Planning Commission on anything that's not on the agenda this evening. See a couple folks here. Okay, seeing none, I guess we'll go on to item number 1, which is the Shoreline Public Access Plan.
Good evening, Karen Stewart, environmental planner. So the Shoreline Public Access Plan, Karen Stewart, environmental planner. Shoreline Public Access Plan was adopted back in 2003, and there are copies for anybody who would like a copy of the existing program or plan. So part of the update with the Shoreline Master Program, there were grant funds provided by the state, and so city staff negotiated with the state to see if we could utilize a portion of those funds to update this access plan, which implements the Shoreline Master Program, although technically it's not part of the Shoreline Master Program. And so we were approved for a very small amount of money, $5,000, to do an update. So it hadn't been updated in 18 years, so it was time for us to take credit for some of the implementation of projects that have actually been constructed, and some of them, like the Grand Avenue Bridge going over West Marine View Drive, is going to be completed this next year, so it's in process right now. So the Shoreline Advisory Committee, who worked diligently on the Shoreline Master Program that we talked about at your last meeting, they also helped staff update the public access plan. And in addition, Port of Everett staff, as well as City of Everett staff from our Parks and Public Works departments, all contributed in pulling together information for this update. And so the commissioners have been provided, it's called Attachment A, update 2019, and you'll notice we're using the similar approach of underline and strikeout through the document to see just what is being proposed to be updated. The overall vision, the advisory committee maintained, and the vision is to implement a continuous and interconnected system of parks, trails, pedestrian walkways, and bicycle paths in and between shoreline areas. So most of our public access improvements in the city are done as part of a development project. It's been very important, obviously, to partner with the Port of Everett as they're going ahead with their redevelopment, as well as other private developers to accomplish these improvements. In addition, we have been working with the railroad to design and permit appropriate railroad crossings, as in the case of the Grand Avenue Bridge. That's partly why it's not under construction right now, is because of an agreement with the railroad to not be working during this time period. A second opportunity to construct these public access projects is through grant funding, typically federal funds that the city can apply for. So this plan helps us compete for those type of funds by showing the benefit and the overall vision. So it was necessary for us to update it. Public access within shoreline jurisdiction is strongly encouraged on-site where such access is not in conflict with water-dependent uses and required on-site for non-water-dependent uses. The regulations provide flexibility in providing public access in the shoreline zone without compromising operations on site. And one of the improvements that currently is closed for the winter months is the Pigeon Creek Public Access Trail, and that's illustrated on page 13. And those of you who have walked that trail will realize that it's certainly a working waterfront area, fenced off on both sides from the railroad as well as from port activities, but then you're able to access a beach area at Pigeon Creek. The public access plan, where staff basically focused on updating in chapter number 1, putting a project summary table right up front. That previously had been in the back of the document, but using that to, at a quick glance in 2 pages, see the status of the projects. And the color coding, the green rows are illustrating projects that have been completed. The red font and the underlining, of course, are words and projects that have not appeared in this document before, so that it's new text. The yellow coloring in the table are projects that are currently under construction, and then the white projects are in various stages of planning or are kind of in limbo at this point in time, but are still in the plan. The document, in addition to the summary table, there are also large-scale maps for the various sections of the shoreline area. There's 9 sections that are described. And there is a description of projects with some illustrations, schematic plans, if we have that information, as well as a short discussion of the rationale, maybe a little bit about permitting challenges, and then presentation graphics as necessary are shown in the document with some illustrations of what future restoration could look like. So that is a quick summary of what's in the document, and we just wanted to have you have a chance to look at this. Again, it was just a quick focus on update for the $5,000. It's not a wholesale change of the plan, but it is updating. The Shoreline Advisory Committee did not come up with new priorities per se. They weren't feeling that they had enough information to do that. So that's my quick summary.
Thank you, Karen. Any questions? Draft? Commissioner Dunn?
So section 8 in the Lowell Larimer area,
That's page 49.
yeah, 49 and 50.
Uh-huh.
So you have a proposed route through a recreation area, and there's no cross streets down here. So is that the city-owned property where the Red Barn Community Farm is?
I am not aware of where the barn is, and I'm wondering if any of the other staff would know.
I believe that's correct.
Okay, because the grayed area is park and city property,
Correct.
and so there's a proposal to potentially put a path through that area?
Yes, there have been discussions between City Public Works and City Parks with Snohomish County looking at linkages.
Okay.
So,
Thank you.
I had one question. I was really excited by all of this whole list, especially all the completed projects. It's exciting to see. My question is 2.4, the Bond Street project. I think I'm not understanding fully if it's just relating to the park on Bond Street, or if there's an interest in creating a connection between Bond Street and the trail, either over or under the tracks.
So-
Is there a potential to connect over the tracks or under it?
so that, the notes for
Karen?
2.4 would be under litigation regarding that, but perhaps,
Yeah, that's correct. We do have some discussions in the form of a lawsuit with Burlington Northern that's kind of been tabled, or not dismissed at all, but some litigation over a requirement that we put into a railroad permit that would require them to reopen access in the vicinity. Where we end up with that, we don't know at this point, but there have been some off and on discussions between the city and the railroad about recreating some connection in the vicinity of Bond Street or Hewitt. But of course, their position is that they don't want any at-grade access for pedestrians crossing their tracks, and so there's not an easy way or an inexpensive way or even a practical way to build a ped bridge over
Sure.
the tracks and over the street and land it on port property. They don't have a square foot to spare, according to what the port tells us, and so they're not interested in seeing that land on some kind of a structure landing on port property. So it's a challenging area, and we'll keep you updated when we have more news.
It was a shame to see that access closed off, but it's understandable. It's good to know that there's still a possibility. Thank you for clarifying that.
one of the things I did also want to mention with that particular proposal is you'll notice there's some new text there, Hewitt Avenue, Street End Park. So that's been a proposal, and I think there's some nice artist renderings. So right at the, so this would be visual access of the shoreline as opposed to actual physical access where you can get close and touch the water. But visual access is important too. And so this is a new proposal of a raised area with the berm that would be to the east side of the railroad, but could be developed as a a small park area. So we did put that in there.
Any other questions? Karen? Just a couple things here. In your memo, you had mentioned that you'd worked also with the port has reviewed it. Did they have any, doesn't look like there's lots of changes in here. Did they have any real comments on the update here?
So the red text would incorporate their comments, some of which were corrections because they had actually done the construction or hired the contractor to do the improvements. And so just trying to make sure the notes were as accurate and complete as possible. So they were very small additions.
Okay. And then just lastly, if you're gonna keep the color coding, I know it has a status what the phase is, but maybe just letting people know that what the colors stand for in your table.
Okay.
Cause I was curious too, but then when you said what the status was, obviously it shows up in the status bar, but similar to what you have on the previous page on page 1, it tells you what the money and the timeframes and something are, just a little color coding thing.
We'll probably drop the
Drop the
coloring,
colors.
just so you could sort of see at a glance that there has been some significant development of shoreline public access since 2003.
Sure, yeah, that's great. Any additional comments? Okay. Well, thank you so much.
Thank you.
That brings us to critical areas update.
Good evening, David Tyler, planning staff. Critical areas, that would be chapter 1937 of the Everett Municipal Code. A little bit of background. Of course, critical area regulation is required under Growth Management Act. The city's first critical area ordinance actually, sorry. Okay. Excuse me. Oh, I just got to touch the screen. There we go. Thank you. So the first ordinance that the city adopted regulating critical areas was in I believe, the tail end of '89, and then became effective in 1990 with the city's zoning code rewrite, which our own Mr. Giffen had a major part in doing. And then previous to that, the city's critical areas were regulated through our SEPA ordinance. So we used SEPA environmental policies to, regulate development in or near wetlands and establish buffers. Seem to recall sort of a uniform 50-foot buffer applying to pretty much every situation back then. And then in 2002, the city adopted a separate, though similar, set of critical area regulations to apply just within shoreline jurisdiction. So those were adopted into the Shoreline Master Program. So those critical area regulations are still in effect. The code says they've been updated, but effectively they haven't. So you've got these two sets of regulations which are diverging in terms of best available science, in terms of the buffers, and so on. So you actually have different buffers for wetlands under shoreline areas than you do for the rest of the city. Then we did a pretty major update to the critical areas ordinance back in 2006. So that established new wetland categories, new rating system, new buffers, and so that brought in sort of the latest and greatest in terms of the science that went into wetland regulations, a lot of which came from ecology, some of it came from the city. We did our own studies. Then again, another update was done in 2015 where we again revisited wetland ratings and updated our best available science. So why are we doing this? Well, for one, we need to consolidate those two sets of regulations that we have currently to sort of simplify, make things more predictable, uniform, streamline the regulations. Of course, we're doing that sort of across the whole land use code. This is one of the early chapters of the code that we're working on. Of course, done metro and parking as well. So we want to also eliminate some of that repetition and then make things clearer, easier to understand, maybe take a look at sort of the organization and format issues as well. Then we also want to incorporate more recent guidance from Department of Ecology with regard to wetlands and in particular buffers. So just to back up a little bit, basic critical areas, wetland streams, steep slopes, lakes, springs, groundwater, and then of course wildlife habitat. The key there is probably salmon and endangered species. The ones we deal with most are probably the ones on the left here, wetland streams and slopes. Seems that that many of the properties that are left, that are vacant in Everett, have some of those constraints, and so we see numerous and repeated inquiries into some of those properties. We also have a pretty good inventory of mapped critical areas, and these maps are from the website. Different maps for different themes and different critical areas. The one on the left, I won't go into details, but we have streams, wetlands on one map, and then geologic hazards on another map. So that's a good resource for us, also a good resource for the public. We're continually updating that as we get new studies. We'll digitize that information and put it into the city's GIS, which is then available to the public. So importance of critical area regulations, we need to protect those natural resources, the few remaining urban type resources that we've got left. Protect property, infrastructure, providing buffers and keeping development out of stream corridors and critical areas can really help preserve our investment. We can use critical area regulations to reduce flooding hazards, landslide risks. Certainly we see a lot of that lately with some of the storm activity and slide activity. And then we use the regulations to really alert property owners as to some of the constraints and potential hazards that they'll be dealing with. As I mentioned, many of the undeveloped parcels do have some of those constraints, and so we've developed a pretty good database on some of those so that we can easily help the public when they come forward and want to develop a piece of property. So some of the agencies that we work with are, of course, Ecology, who regulates wetlands and shoreline areas. Fish and Wildlife, we work with them on in-stream work. For example, if somebody needs to cross a stream with a driveway or something like that, we'll need an HPA permit, so that's part of the review. And then they also look at projects that impact wildlife habitat, fish. Corps of Engineers works through wetland fill issues, and then National Marine Fisheries, they look at endangered species and fish, salmon. So the basic changes that we're trying to undertake here would be to essentially create one set of regulations for the whole city, to develop also the shoreline areas, to update our wetland and buffer information to reflect the best available science. As I mentioned previously, Ecology has done some additional work. They're continually working on wetland science and updating some of the guidance on that. And then we also want to incorporate some of the administrative interpretations that have been issued over the years, specifically in regards to some of the endangered species listings. So we're required to do special studies to evaluate salmon habitat for projects that may impact salmon. We want to standardize all of the reporting requirements for critical areas. So right now you've got different report requirements depending upon what type of critical area you're talking about. We'd like to consolidate all that into one section of the code, and then consolidate some of the standard requirements that apply across different critical areas. For example, things like fencing, putting fences along edge of buffers, signage, hazard tree protection, that kind of thing. And what we're not proposing to do here is really make substantive changes to the regulations. This is really just an update in a consolidation. So we're currently working on a internal draft, and that hopefully will be ready to go here very shortly. And then once we're done with the internal review, we'll be doing some outreach to various agencies and stakeholder groups and asking for comment. Then beyond that, we'll be coming back to you on the 15th of January with a draft. So you'll have a chance to look at that and provide comments and feedback and suggestions. Then a public hearing on the ordinance is tentatively scheduled for February 19th. And then we'll have concurrently with that the Shoreline Master Program public hearing. So that's it for critical areas. Available for questions?
Any questions for David? Mr. Zelinski?
David, could you give us an example, an illustration of where the critical area regulation within the shoreline might be different from the critical area regulation for the same critical area, but
Sure.
outside the shoreline?
Yeah. Wetland buffers. You've got basically 2002 wetland buffers, which I think start at 25 feet, 25, 50, 75, 100, something like that. And those have come up substantially as of either 2002 or 2006, something like that. So the current citywide critical area regulations have much greater wetland buffers.
I was curious, just historically, how come there are two separate? I understood you saying the idea is to get consolidated to one.
How did we get to
why-
two?
Yeah, how did we get to two? Was it one before and someone had a idea to divide it to two, or has it always been two? And
Alan Giffen, Planning Director. This is the result of a lawsuit, or an appeal, I should say, of our Shoreline Master Program when it was adopted in 2002. It was appealed by several environmental groups, and we went through an extended settlement discussion with the appellants, and the outcome of that was to keep the previous code, or the code that was in effect at that time citywide, within the shoreline jurisdiction. And so that was incorporated into the settlement agreement that we had with the appellants, and it was approved by Ecology. Subsequent to that, we updated our code in 2005, 2006, when the greater buffer standards came into play in the rest of the city. But we were under this agreement with the environmental groups and the Department of Ecology with the regulations in the shoreline area, so we did not want to open that up, and so that is why we have two different sets of regulations. And now it's been long enough that a lot of those properties have either been developed or may never get developed, but to create standards that are more uniform throughout the city. But we're still relying on some of the science that supports the designations and standards in the Shoreline Master Program in wetland areas, and so we're probably going to have a bit of a more crafting to do to make reference back to some of the studies that have been done in the shoreline areas that may end up with slightly different standards than what we would have elsewhere in the city, but it'll have much greater consistency once we're done with this process. But there's been a lot of work over the years and a lot of background and expectations by some of the parties that have been involved over the years, and so we're having to walk kind of a balance between some of those previous discussions and where the science is really good, even though it's older than some of the more recent science. It's stuff that we did just in great detail down in the estuary, and so it's we're trying to get them all synced up, but we may have a few exceptions in the shoreline areas still.
so I guess the crux of my question was just if at one time it was determined that having it separate was a good idea, ultimately what changed, and now is the time to put it back into one, and those, it's not going to be creating other maybe unforeseen problems, or I guess give rise to additional litigation or
Well, yeah,
concerns?
we're hoping not. I mean, last thing we hope for when we're amending regulations is litigation. We want to try and get it right. And when we don't, then, you know, we always have the opportunity to fix things when we learn that something isn't quite right. So, and that, you know, for a big process, for example, Metro, you know, if we thought that that was perfect, we're probably wrong, and somebody's going to find a few things that we either didn't think of or things that didn't quite get right the first time through or totally consistent, you know, but that's an example of a major program. Same thing with a wetland critical area overhaul is that you sometimes don't catch everything first time through.
Any additional questions for David? I just had a couple things. I think it was earlier this year that I know the development community had approached Department of Ecology and others about the rating systems for wetlands and how the scoring's going, because they've got the new scoring stuff that came out, I think, you know, last year, 2015, whatever it was, and they weren't capturing what the true essence of the wetland was. So categories were getting pushed higher when they should have been potentially a lower score on the wetland rating forms and things like that. And I guess there was some new information that DOE put out as far as their scoring system and all that. I just want to bring that to your attention if you weren't aware. They had sent that out earlier this year, and then I believe it was late last week. I think the Corps had some stuff that was related to the Clean Water Act and how they're going to be processing and considering whether or not it's the water of the U.S. and how you move forward on those things. And so those are two things I know that just happened over this last year that may have some impact on your update or whatever. Just was bringing it to your attention. I'm sure you're already aware of it, but
The Corps, I haven't seen their information yet on the ecology information. I know they put out a bulletin in, I think it was July, which does provide an updated tier system for how you establish buffers. You can have different alternatives. So you can go with like a 3-tier, which has these big jumps between the buffers, or you can do more like 6 or 7 tiers, which is more gradual. So one point might not make, you know, a 40-foot difference in your buffers.
Right.
So we're looking into that.
okay, great. I'll forward you what I got late last week from the Corps on that. There was 2 different things I think that came out, so just so you have it. So.
Okay, thank you.
Any other questions or comments? No? Okay, looks like we're on to sign code. Fun stuff.
Just a minute here. Okay, this is the previous section of the code, 1936, that deals with signage. Again, a little bit of background. We adopted the major overhaul of the zoning code in 1990. So that was the same time, of course, we did the critical area regulations. And then we've done updates in 02, 08, and 2012. 2012 was when the Evergreen Way E1 MUO zone was established, and that brought in separate sign standards for that zone. Also, more recently, there's been some court cases that have addressed signage, including the Reed versus Gilbert, which is a Supreme Court case dealing with essentially free speech. So I'll say a little bit more about that in just a minute. So we've got to make sure our ordinance is current with the recent case law. And so just to back up a little bit, we've of course amended our zoning code many times since 1990, and we've added zones, we've added uses, and that's resulted in a lot of our standards being sort of dispersed throughout the code. We found that with parking. We've also found that with signage, and so this is an opportunity to take those standards that appear in different parts of the code and pull them back in where they belong, which is to the sign chapter. And it can be very difficult to actually figure out at times, depending upon what zone you're at or, what type of use you're looking at, which standards to apply. And then also with some of the court cases, some of the science standards that we have in place right now could be unenforceable. In fact, probably are unenforceable, particularly in regard to some of the non-commercial signage. So we're trying to make the regulations basically a lot simpler and easier to use, do these basic streamlining items, so eliminate duplication and conflict, bring everything back into Chapter 36, and then ensure the regulations are content neutral, and that speaks to the Reed versus Gilbert case that came down. And what they said was that for some of these non-commercial signage, you cannot make distinctions based upon, who's putting up the sign or what it says. So for example, political signs. We have a chapter in the code that addresses political signs specifically. That's kind of an ideological message. The court seems to say that we cannot look at those independent from other types of non-commercial signage. So one of the things we're thinking about is eliminating that and redoing our temporary sign standards to treat non-commercial signage uniformly, so that there isn't a lot of distinction between different parties. And then we also want to do various cleanup actions, housekeeping, organizational changes to the code that'll make it easier to work with. Again, there are a lot of items in there that either we don't use or duplication. And so, for example, the enforcement section. Do we really need its own enforcement section in the sign code when we can put an overall enforcement section in the land use code that addresses everything under it? So changes proposed at this point, I'll just bullet point those. Again, pull everything back into Chapter 36. We've got some standards now, for example, that apply to bed and breakfasts, which aren't in the sign chapter. They're off in the administrative provisions part of the code, so don't belong there. And then we, of course, want to amend our provisions for temporary signage. That's probably going to be the most difficult piece right there, because of the direction that the courts provided that said you can't make all these distinctions. Okay, well, what can we regulate? We can probably regulate the structure itself, or the height, or the placement, but again, not the content. The duration, that could be a challenge for us, because some of the case law says you can't put time limits. For example, you can't necessarily put a time limit on how soon before an election a political sign is put in. You can put a limit on when it comes out, but not necessarily before it goes up. We also want to take some of those sign standards and put them in a format that's a little bit easier to access and use. And one of the things we're working on right now is taking all those standards for the different sign categories for freestanding signs and wall signs and putting them into a table. Right now they're just kind of strung out in a narrative format, and so it's kind of hard to navigate. So that'll be one of those access changes that I think will make a difference. One of the things we've talked about is reducing the number of categories. We've got a couple categories that only apply to a handful of zones, and so we really don't see too much activity in those zones, so do we really need a separate sign category? And then one of the policy questions that we're also kind of grappling with right now is freestanding signs, whether we want to require that in certain cases that they be monument signs, so lower, maybe wider, with a more attractive base versus a pole sign. It's kind of one of those things we've been having some discussion about. And so we'll probably bring a draft with maybe a couple of options that the Planning Commission can take a look at and give us your feedback. So we're almost at the point of having an internal draft ready. That should be ready in the next couple of weeks, I would say, and then we'll start our outreach. got a whole list of sign companies that we work with on a regular basis, so we'll make sure to circulate drafts to them, as well as neighborhood groups. This is on the same track as critical areas, so we'll do another briefing in January and with a public hearing on, well, I guess that would be a month later, so March 19th. So more detail to follow at the next briefing.
Any other thoughts that you're having on the Gilbert case as far as regulating the content? I mean, there's been discussions that I've had in the past about doing it by zone, so it's, you know, the R zones would be different than the commercial zones or whatever that may be, so you can limit the size and things like that. Is that kind of the areas you're thinking about?
Exactly, and what kind of distinctions can we make?
Right.
You know, do we have to lump everything together? It's kind of interesting to read some of the ordinances that, well, it's not interesting, but it's required
Fascinating.
what other jurisdictions have done post-read. And there's a real mixed bag. You know, some of them have taken, you know, sort of a radical approach and whitewashed them, and others have said, no, we can still put these nuances in here. And so we looked at 6 or 7, and they're kind of split in terms of, do we want to keep, you know, political signs, do we want to keep real estate signs as separate items? So we're trying to weigh that and figure out the best approach now and what those proper distinctions are. Certainly, signs in the right-of-way could be looked at differently from signs on private property, commercial versus non-commercial, and maybe a couple other things.
Daycare, home occupations, all of it. So.
Yeah.
Any questions for David at this point?
I just have a timeline question about when will the, so 15th, January 15th as well, we will be doing the draft revision, but will we get will we get it before then to take a look at it? Or?
Yeah, I would expect we'd have it much before that because we'll have an internal review done fairly soon. We're just sort of putting sort of the final touches on that. So yeah, I would expect to have it well before the 15th.
Any additional questions? Thank you, David. And it looks like we're on to item 4, Land Use Consolidation.
Well, one David to another. David Stahlheim, Long Range Planning Manager, and hopefully this works for Jeff. He'll come out and tell me if I need to move. As we've been talking about an update to the land use element of reducing the 28 different land use designations down to 6. Looking at that, and I warned you at the last meeting that part of this also requires us to revise the text, and it also gives us the opportunity to look at the text and the small quantity of goals, policies, and objectives, which number 199 of them, and look at which ones that may not be necessary anymore. And so I provided you with a really rough cut of the land use element, the text. Really what we did in here is we updated some sections as needed. There was some old demographic information. There was language about if light rail is approved by voters, things like that, those things have been done. And so some of those things that are clearly some updates, we took that opportunity. But then to try to start doing some more serious editing of the 199 goals, policies, and objectives, started looking at them and, you know, which ones are good at really articulating a vision, which ones really don't advance that, and which of them also are very clear as to direction that regulation should take. For example, there's a lot of policies for critical areas, and as much as I didn't like how many there are, they're actually very specific as to what the regulation should be. And so we're trying to avoid any kind of substantive changes in this first cut of things, and really any wholesale editing. So if it was directive to what the regulations are or very clear for the vision, then the initial take was to leave that in. There was quite a few that kind of failed that test, and some were redundant. Some of it had a lot of explanatory text that led into something that even talked about the process that led to adoption of, the policies, and that doesn't really necessarily have to continue to live in this document. So our timeline, and I don't know if anyone has had a chance to read it, we weren't really expecting feedback necessarily tonight, unless you're ready and eager to go for that. But the idea was that the next session was scheduled for February 5th on this, and for you to be able to take this time, and I would actually appreciate, individually, if you have notes, particularly if you saw something that was struck out that think should stay, is one area that should stay in the document, because you think it articulates a vision or regulations, and it's not still in there, then I want to hear about that. If you see some that you think should go, would love a list of 10 or 12 of that, or any other ideas for consolidation, but we didn't want to go too far with any of that. But if you could do that, then we can come back February 5th with either some compiled notes that we have from you, and then we can talk about what the draft is, and we have it scheduled for public hearing on March 5th as part of that. So when we did the file save as, we actually kind of did it really quick, and so one of the good things is that you got a lot more paper, is that you actually have one version where all the track changes were taken off, and you got one with the track changes. And so sometimes it's nice to read the clean version, because then you can see what's left. But wanted to make sure that you actually got the track changes version, so you could see what went away as part of that, so that you can see both of those. And so it kind of depends on your reading and reviewing style of how you want to approach that. But other than that, that's all we really had for tonight. If you had any things and want to discuss any specific items, I'd be glad to take that up now.
Well, I thank you for giving us time to look through this, since we're not coming back until February on it, so that'll be very helpful. So thank you for that.
I have a question.
Commissioner Dunn?
I don't have a question on the land use, but more about the process in general. So thank you for undertaking this effort. Less paper, it's a good paper reduction policy. But how will you be addressing existing ordinances that reference land use codes? Because you've got the consolidated description, but what will the process be for any existing ordinances that are referencing land use codes? Will they be adjusted to just reference the new land use description, or will you open them individually? So for a specific example would be the cannabis stores ordinance, where cannabis stores are allowed to be located in 2 of the 5 current zoning equivalents under industrial. So that would either expand where they can be located, or will you be looking at each ordinance individually?
Yeah, it's a good question, and I think Alex Lark had some similar kind of questions that he posed to us last week. But so what we're doing right now is just the plan, and it's not the regulatory side of things. So there's no changes whatsoever. So none of the going down to 6 land use designations does not affect the zoning designations whatsoever. So they will all continue in existence. And so all this does is it sets the stage that says, here's our vision for single family areas, multifamily, and the kind of the big policy 30,000 foot level thing. But this is part of the stage of code simplification and code update that would be citywide, and that's really the next phase. And so your question of how we're going to do that for, say, marijuana stuff is really in the next phase after we get done with this policy phase right here. And so we're starting that work right now, and again, the concerns about how we simplify single family zones or commercial zones, all those types of things, is really good to hear those concerns right now, because as we start drafting that code update and simplification process, we can start weaving that into that. So I don't have an answer for that of how we're going to do that yet. But I can tell you, we're 28 different land use designations down to 6. I think, if I remember my memo, I think we have 31 different zoning districts. We won't have 6 zoning districts as a result, so we're not gonna get that simple. But we will not have 31 in our proposal. My guess is it'll be somewhere in between, so, but we're still trying to start carve that out, and we're gonna have a very iterative process. We're gonna come back and forth as we start getting into the code thing with the Planning Commission.
Okay. So the code review will most likely be this summer?
It'll happen over the next year. So the idea, kind of tied with the other development code parts, is that so the work plan is internally starting right now, and we're anticipating that we'll have a development code, or we're trying to have a development code by the spring of 2020 for public hearing process. So it's really going to be probably about a 1.5-year process of discussion, because those are really meaty conversations to have, not only with the Planning Commission, but with neighborhood groups and the public and stuff like that, because it's a potential pretty significant shift in approach to things. Not a shift in necessarily regulatory or substantive things, because we're not trying to do large-scale shifts in that, but we're trying to simplify how the code and how we approach that.
Okay, thank you.
I would like to add that one of the things that we're doing as a result of one of the mayoral directives is a housing affordability strategy, or a housing strategy in general, not just for affordable housing, but all forms of housing. And we did a briefing for the city council a couple of weeks ago on some potential housing strategies. It was just more of an update and report to them than a proposal. But we did talk about, with regard to housing affordability, perhaps making some changes in some of our codes in the type of housing that's permitted in different zones. There have been a number of cities that have been going to that lately, and we did get some feedback from some of the council members to do that very cautiously, and probably with some design standards that would ensure that we don't get incompatible buildings in terms of scale, or we didn't get into actually talking about architectural styles or anything like that. But for example, Snohomish County made an amendment to their code where they will allow duplexes in any single family zone. It used to be they would only do that with a lot that was 1.5 times the minimum lot size, but now those are allowed in any single family zone regardless of the size of the lot. Olympia just went through a really, I think, kind of a bold exercise where in their single family zones they are allowing duplexes, triplexes, and up to 4-unit buildings, and they have some infill design standards that go along with those. And so those are the kinds of feedback that we're seeing from other communities and from legislators. We expect, in fact, I'm going to a meeting tomorrow where some of the development community and planning directors will be talking about potential legislation. We've seen a few drafts that have been floated that could be introduced in the legislative session that would preempt local authority to regulate certain types of development in even single-family zones. And so those are some things we want to make sure that we have an honest discussion about with not only the development community and the legislators before they force something on us, but what they're trying to address is the housing affordability crisis that has been affecting Washington in the last several years. And so that's why we have these things come out of the legislature from time to time that would preempt local zoning authority. And so we're not too wild about that idea of preempting local zoning authority, but the pressure is there, and the challenge is there with the cost of housing and the lack of housing production when we've got these huge growth targets. And we'd have to grow at least 2.5 times the pace that we've been doing since 2000 in order to hit those growth targets. We just don't have a lot of undeveloped land, and it's challenging for the redevelopment of a lot of the areas that are designated for higher growth. And so now we're seeing these types of proposals from the development community or legislators that want us to, not just us, but all cities to be more proactive in the types of housing that they allow. We're not going to get into that as part of the land use element revision in terms of standards or that question, but that's something that could be a follow-on in the following year after we update the land use policies and have that dialogue with the public and commission and stakeholders.
Was part of the discussion with regard to tiny homes and or accessory dwelling units? Was that part of your discussion and the affordability of?
Well, it's fair for discussion. We recently did go through an amendment process where we do allow for the detached accessory dwelling units. What we normally see when people are talking about building tiny houses as an affordable housing option, usually what they are talking about are not, I shouldn't generalize it that greatly. Often we hear from people who want to get the building code standards as well as the zoning standards and do things that really aren't safe or sanitary just because it's cheap and there's a need for homeless people or people with just to be able to have something that's more affordable. And we're not talking about the building code standards, of course, but you know, we do allow the detached accessory dwelling units, attached accessory dwelling units. Seattle is looking at allowing both on the same lot, and that has been challenged in their own process. But you know, those are the types of things that this housing affordability crisis has generated some responses in various communities like that.
And yeah, some of those things that the legislatures they're pushing to do is to require that you allow those and
Increase the density exponentially, yeah.
Which is, I've read all the stuff that they had put out, and it's kind of scary when they take that authority away from your local community and, you know, how neighborhoods have shaped over the years. So anyways, should be interesting to see what happens upcoming. So.
And there's such a huge demand for it anymore. It seems in the past 5 years, I've seen a lot of interest in it, just from an architectural standpoint. But
Commissioner Zielinski?
Just one observation, David. I did look through this document, and I noticed a lot of winnowing out of a lot of objectives and policies. And I think it would be helpful for both the commission and for the public to kind of see what guiding principles you're using. You sort of spoke to that verbally a little bit at your introduction, but things that would cause you to delete the policy. An example, I saw one objective that I thought, gee, that's pretty important. I think that you were deleting, and I thought that should stay. But then when I read a little farther, I saw that the subject was really covered adequately by a policy that followed up. So then I thought, okay, so it makes sense to do that. But I think if you had like, maybe just, if you got 3 or 4 kind of guiding principles that you were using, it would help the commission and the public kind of see the logic behind why certain things are being proposed to be deleted.
Yeah, I think in the memo today, and you know, I tried to do that a little bit, but honestly, it was a little weary running through about 60 pages and 199 policies to figure out what the rationale was. And you know, and then as I was going through it, then I realized I had to kind of develop some kind of system, but it was that where it really was trying to things that were very directive again, and very specific, not to lose that, you know, because this process wasn't about kind of revisiting policies. It was really about getting rid of things that just wasn't advancing anything. And so, yeah, so again, yeah, I think if you see any other, questions or patterns and some other things in there, shoot it to me and then we'll try to articulate it. I really would like to, I talked, just off the cuff, I asked our new economic development director, I said, and Dan was in the private sector, I said, Dan, so how long do you think a land use element should be if you were out in the private sector and reading something like this to kind of articulate? And he said 15 pages. Yeah, 1 pages. Yeah, I mean, it's just, who goes to it, and who's going to go to it when it's 60 pages long, and I haven't even given you the appendix. So, to that, it starts to lose what that vision is and the clear direction. And so, I think it could go further, but again, I think that's a whole nother kind of task, and it starts, requiring merging of policies and a whole bunch more shifting that is a little bit probably beyond our scope right now. So I will try to articulate it and go back through with I do have a very good editor in chief here, so he goes through and makes sure that things aren't being lost too much either. So.
You worked hard on a lot of those policies.
It's amazing how open he is to other people editing his work, though, too.
They're not my children.
Any other comments or questions for David or Alan on this? Thanks, lots of work. We'll get comments back to you,
Okay.
hopefully. Last item is the bylaws, and hopefully I can make this real quick because, and although I'm not opposed to the additional language, I think that sentence right before the language you're proposing needs to be just amended slightly. So I'm not prepared to vote on that or vote to approve it this evening, just letting you know if somebody makes a motion. And I was hoping maybe Kathy, if I could get what you prepared here, I think, and gave to us tonight, and then maybe I can I think it's just taking a couple words out or massaging that sentence before, because it says, well, I'll just read it. The alternate shall have the privilege of participating in all discussions before the commission and shall serve as a voting member in the absence of members when asked by the chairperson, and when serving shall have the same powers and responsibility. And then it goes on to say who gets to vote. So I think it just needs to say, get rid of that they're not asked by the chairperson somehow, and that who has the voting authority. So, and then secondly, on just like this evening, we had 2 alternates voting, but it was only on minutes. So do we need to say something about it's a substantive thing and not just a minute-taking thing? So those are the kind of 2 things that I think about, and I'm not against what you prepared, and I think it's great. I think there's just a little bit slightly more massaging to do, and maybe I could take a stab at doing that too.
Just one reaction, the language that I put in there about the commission recommendation was intended to address the issue of just procedural things like voting to close debate or voting on minutes.
Right.
That kind of thing.
Yeah, perfect. Perfect, that'd be great, thank you. Again, so if somebody wants to make a motion, I'm just letting you know it has to be done by a majority of the regular members, and we only have 5, so if we can
I'm
maybe
fine,
take
I'm
another
fine with
stab.
waiting.
And I don't really want to keep this going on. So anyways, I think we just a little minor.
I'm fine
tweak
with
and-
that, I'm
okay.
fine with waiting.
Great. Great, thank you. Any other business from staff tonight? Okay, well, before we adjourn, thank you, Commissioner Dunn, for serving. That's great.
Thank
Best
you.
of luck on all your future endeavors.
Yeah, thank you. It's a pleasure to be a public servant, so I appreciate the opportunity to get back. Thank you. You may not have a second alternate I don't know.
Yeah.
And then the entire conversation went over the last 3 years.
Well, Merry Christmas, Happy Holidays to everyone.
Yes.
We'll see you next year, I guess, early next year.
February 5th, huh?